Be ready. Start. It must therefore be taken to be the law that where the government is dealing with the public, whether by way of giving jobs or entering into contracts or issuing quotas or licenses or granting other forms of largesse, the government cannot act arbitrarily at its sweet will and like a private individual deal with any person it pleases, but its action must be in conformity with the standard or norms, which is not arbitrary, irrational, or irrelevant. The power or discretion of the government in the matter of grant of largesse, including award of jobs, contracts, quotas, licenses, etc., must be confined and structured by rational, relevant, and non-discriminatory standard or norm, and if the government departs from such standard or norm in any particular case or cases, the action of the government would be liable to be struck down unless it can be shown by the government that the departure was not arbitrary but was based on some valid principle which in itself was not irrational, unreasonable, or discriminatory. Equality and arbitrariness were thus declared sworn enemies, and it was held that an arbitrary act would fall foul of the right to equality. Rule of law principle primarily applies to the power of implementation. It mainly represents a state of procedural fairness. When the rule of law is ignored by an official, it may on occasion be enforced by courts. As is evident from the above, the expressions arbitrariness and unreasonableness have been used interchangeably, and in fact, one has been defined in terms of the other. In order to be described as arbitrary, it must be shown that it was not reasonable and manifestly arbitrary. The expression arbitrarily means in an unreasonable manner, as fixed or done capriciously or at pleasure, without adequate determining principle, not founded in the nature of things, non rational, not done or acting according to reason or judgment, depending on the will alone. Further, even though the classification doctrine was never overruled, it has found less favor with this court as compared to the arbitrariness doctrine. This principle is now uniformly followed in all courts more rigorously than the one based on classification. Arbitrary action by the administrator is described as one that is irrational and not based on sound reason. It is also described as one that is unreasonable. The power of parliament, or for that matter, the state legislatures, is restricted in two ways. A law made by parliament or the legislature can be struck down by courts on two grounds and two grounds alone, namely 1. Lack of legislative competence, and 2. Violation of any of the fundamental rights guaranteed in Part 3 of the Constitution or of any other constitutional provision. There is no third ground. We do not wish to enter into a discussion of the concepts of procedural unreasonableness and substantive unreasonableness, concepts inspired by the decisions of United States Supreme Court. Even in USA, these concepts, and in particular the concept of substantive due process, have proved to be of unending controversy, the latest thinking tending towards a severe curtailment of this ground, substantive due process. The main criticism against the ground of substantive due process being that it seeks to set up the courts as arbiters of the wisdom of the legislature in enacting the particular piece of legislation. It is enough for us to say that by whatever name it is characterized, the ground of invalidation must fall within the four corners of the two grounds mentioned above. In other words, say, if an enactment is challenged, as violative of Article 14, it can be struck down only if it is found that it is violative of the Equality Clause stroke Equal Protection Clause enshrined therein. Similarly, if an enactment is challenged as violative of any of the fundamental rights guaranteed by clauses A to G of Article 19(1), it can be struck down only if it is found not saved by any of the clauses S to 6 of Article 19 and so on. No enactment can be struck down by just saying that it is arbitrary or unreasonable. Some or other constitutional infirmity has to be found before invalidating an act. An enactment cannot be struck down on the ground that court thinks it unjustified. Parliament and the legislatures, composed as they are of the representatives of the people, are supposed to know and be aware of the needs of the people and what is good and bad for them. The court cannot sit in judgment over their wisdom. In this connection, it should be remembered that even in the case of administrative action, the scope of judicial review is limited to three grounds, namely 1. Unreasonableness, which can more appropriately be called irrationality, 2. Illegality, and 3. Procedural impropriety. See Council of Civil Service Unions versus Minister for Civil Service, which decision has been accepted by this court as well. The phrase begins life as a literary expression. Its felicity leads to its lazy repetition, and repetition soon establish it as a legal formula undiscriminatingly used to express different and sometimes contradictory ideas, said the learned judge. Thank you.